Okay, thank you back. Thank you guys for keeping and coming to the next part of this conversation that is very, very important for any individual who wants to secure, as we talked about, the future of their dependents, to reduce on any conflicts that may be there or any long, emotionally draining, difficult process that may have to be taken up by the stake and may take a lot longer with a lot more associated costs that would otherwise have been saved by simply having a declaration that is legal and valid in the form of a will. So thank you. Hunter, yes, so the other thing that we need, I guess, to talk about is when we talk about this will, should it be notarized? Should you go to a lawyer, an advocate of the High Court of Kenya, somebody who is educated and legally, capacitated to be able to do a will? Or can you sit down with your villagers or your friends, write something down and assume that can be able to be declared and be legal without any challenges from any parties associated with the will? Or should you go the right way, which is get a lawyer who understands all the legal, technical jargon?
Yeah, and George, that's a good question in light of the fact that, one, there's economic turmoil all around the world. There's a realization that people don't have much disposable income due to different circumstances. And as you go along, you realize people will want to do certain things, but they're costs that are inhibitive. One of the most inhibitive costs is costs. And we recognize that profession where people will pay only as a last resort. So they come to you when things are really, really bad or when they have no other alternative. So what I would say is, number one, with regard to drafting a will, the simpler, the better. I would say if you feel that going to a lawyer is fairly prohibitive, just make it as simple as possible. Write what you want to do with your property, who you think should get that property, and then get 2 independent witnesses to sign on your document. That sounds very simplistic, and I know it does. I know there are certain scenarios where people have gone to court and contested the fact that a will was drafted in a particular way. There is wisdom in having a legal person look at it, because there's certain nuances when you're drafting a will. But again, I'm aware of the reality of what people face on a daily basis. And because I say that, I say draft as simple as you can, declare what you want to declare, have your 2 witnesses, put it somewhere in safekeeping, let anybody who wants to contest it later on, contest it. But I'm saying that because I would rather you had something written down than not had anything written down, because of the issue of cost. That is important to me. The default setting as a lawyer would be, please get a legal expert to draft the document for you and help you understand what needs to be put in, how it needs to be said, so that there's no ambiguity, and so that everybody is aware of your intentions, as clear as they want it to be. Because sometimes when we write independently, we are not very clear, and there are things that may seem confusing. More often than not, a lawyer will help you decipher that. So you don't need a lawyer, you don't need a notary public, you don't need an advocate. Legally, you don't. You can declare what you want to declare. And that's why initially when we started this conversation, I said there's an oral will and there's a written will. In an oral will, you say it amongst people, there's no lawyer present, but there are independent witnesses and your family is present. Some people do that in the hospital beds, and they go to court and say, whilst he was in hospital, before he passed away, he said X, Y, and Z. That's why within the law, there's still a provision for an oral will. And even a written will, you can still do it yourself. But if you have the chance, if you have the capacity, if you're able to, please get someone with legal knowledge to help you run through it. And more often than not, you don't need to see the signature of a lawyer in your will. you'll see that you'll notice that it's written with some legal language, but the lawyer doesn't really need to sign off on it.
Yeah, and I think it's important that we talk about also the role of professionals, especially when we want to invest or safeguard our investments or properties. Right. Because I remember we had a conversation with a person who is a qualified civil engineer, and he was talking about how buildings fall, and these buildings fall just because somebody did not engage a professional because of the avoidance of costs, but they end up trying to save pennies and losing dollars. So it can easily be a conversation of trying to save on the pennies, but you lose out on the dollars simply because you do a will that becomes ambiguous, easily challenged, and ends up being more confusing than if you never you wrote down or recorded anything. So yeah, I think it's important to also understand the role of a professional in simplifying what you're trying to do. Yeah.
And let me give a very real example, because it's important to understand that in as much as you get professionals to draft this for you, the question always remains, what is your intention? Yeah. And one of the famous cases that I see being litigated in court is the Njenga Karume issue. Yeah, yeah. And in my understanding, Njenga Karume had certain intentions, and he placed that in his will. Yeah. But you still see, when you go forth and you read some of the court documents, there's still people that are unhappy with the way that will was written. Yes. So at the end of the day, it depends on what you want, and the lawyers will try and guide you to do what you want, to dispose of your property in a particular way, to bequeath your property in a particular way. But there will always be people who may be unhappy with how you do it. Yes. And the bigger issue that we always advise our clients to do, in as much as it's not legal, is to start having the conversations. The way you train or you coach or you mentor people into certain things or professions, to make people aware that perhaps I will do this. Give a little bit of a hint. Understand who your dependents are. Understand how they operate. Yes. Understand if they will be unhappy if this is given to someone else as opposed to given to another person. That is a social issue that legal experts may not be able to tackle holistically. It's really about you and your family and your dependents. Because people who go to court sometimes say, I should have got a bigger share. But you may find that the person who has drafted the will, in his mind, is thinking, yes, I should have given this person a bigger share, but I don't think they're responsible enough. Now that's not something that a lawyer can fix.
Yeah. That's the relationship with the dependent, rather than
correct,
a legal term that you can be able to describe in a will. So thank you for mentioning the Njenga Karume case, and we'll go back to those landmark succession cases and some of the challenges that we have seen and what a layman can be able to pick from them and at least be able to do that. We understand that the bigger the wealth, the bigger the inheritance, the more likely the problems in succession come, because the more money you have, the more in demand or in problematic execution of a will can become. So yeah, we'll have that conversation as we talk about that later on. So the other thing is, I'm 35, I've come, we've written a will, but I am getting older, I'm acquiring more assets, I'm having more children, I'm having more dependents, I'm getting causes that I'm interested in like reforestation and all these things that have changed over time. So at what point do I now need to change a will or cancel a previous will? Then how do I change or cancel? Do I need to totally cancel? Do I create an addendum to the previous will to encompass this change? How do you go about cancellation or changing a will from a previous will?
Okay, and thank you for that. Again, that's one of the things that we address, and the benefit of having a legal person to address that is very critical. More often than not, when we write wills, we always say that this is the last will and testimony of XYZ. It cancels this will and previous codicils. Now, you can have a scenario where you have drafted a will and you want to add on to it. And there's some document known as a codicil. You don't have to go through the uh, full document of the will and writing it afresh again. You could add what you are referring to as addendum. You could write something in addition to that to supplement that will, what we call a codicil. And with regard to the time frame, it can be at any time. You may write a will today and realize 4 weeks from now that there's a material issue that you didn't incorporate into your will. You're always at liberty to change that. However, the basic tenets of ensuring that a will is valid, including a codicil, is that you still need to have your witnesses ready to confirm your signature and know that there's a document that existed that in which you are declaring how your property needs to be handled. So there is an opportunity to add on to what you have. There is no limitation in time of time and space. But one important factor is one to declare. You could alternatively decide that I'm doing a whole new will altogether. Because there are certain cases that people have said there was one will, a 1995 will, and then there's a subsequent will. One case that comes to mind is the late Garrison Kirima. That was a factor. There was a will that was written within the 90s, and there's another will that was written whilst he was in a hospital bed in London. So that is also a contention, because lawyers will help you put some wording there that either confirms this is the last will and you've revoked all other wills, or wording that says this supplements a previous will.
Thank you. Thank you for mentioning that. And I think you've also mentioned a little on whether somebody can be able to change. Yes, they can be able to change or have a new one, and when they can be able to do that. So can they and when? So I think you've answered another question that I was to ask later. Of course, they can be able to change. Of course, mentioning whether this new will, like you said, cancels the previous wills that have been done. And this is something that you can be able to actually do. Then I think the other one, you may have mentioned about it or not mentioned about it, which is, do you give copies of the will to beneficiaries, or you give to people who are not beneficiaries to the will, or do you leave it with a lawyer? What if the person who has a copy dies before you? Yeah, maybe you can mention something about that in terms of distribution of copies of this will.
In a nutshell, I'd say give it to who you trust.
Yeah.
And in saying that, I'm being very liberal. You may give it to your lawyer. And I handled a scenario a couple of years back where a will was given to a lawyer. The lawyer passed on before his client. And then later on, his client passed on. And what happens within the Law Society of Kenya, if a lawyer passes on and their matters are, the LSK allocates someone to another lawyer to deal with the matters. Now, imagine you're in a law firm where someone has got numerous files and numerous cases. By the time you get to that particular document, client document, you'll be very far. Remember, you're running your own law firm and you're trying to manage someone else's law firm. So that was a scenario where there was a will, but no one could trace it. I always say, and like I mentioned, like I alluded to earlier on, give the person you trust. Give a person you trust, put it in a fixed box within a bank. Banks have the ability to store documents safely for individuals, but as you make that storage, you alert someone. So always alert someone that there's a will. There's a will. So that in any event, whether there's a conflict, in order to elevate that stress level, someone will know that he mentioned that there's a will somewhere in a bank. Even if you say, I have a will in a bank, no one can access it until you go with court documents saying, we've got this court document, we understand there's a will, we want to access it. So I would say trusted individuals, either professionals or friends, putting it in safe deposit boxes within banks or other institutions. That's the way to deal with it. And most importantly, notifying people that there is a will that exists. Trust is the underlying issue with regard to how to share such a sensitive document.
Makes sense to be able to do that, because it becomes difficult when you say there is a will, when you go through the process of writing the will, but you can't trace or have the document to be able to execute it. Makes a lot of sense. Then, of course, the other thing is now you may have not written a will, as most Africans do. You may have owned properties or invested in things that your family is not aware of. These things happen because culturally there are people who always have the belief that a man should not show their wives or their children all that they have for whatever cultural reason. What happens in such cases? You don't have a will, you have properties that no one has any clue or is aware of. Even the properties that people are aware of, is nothing that is written down. How do we now approach this matter through the state and the legal provisions that have been provided?
Yeah, and John, that's another really good question, and it's interesting. I'm handling a matter, and I can talk about it briefly, just very similar to that. This individual passed away, and he died without a will. Now his wife has gone through the process, or has started the process under probate administration. That's the legal term that we use, and has applied for letters of administration because the person has died. Again, you'll hear this big word, intestate, without a will. Now, we have done searches for properties all across this country. We have sat with individuals who we think have knowledge of this property. Sometimes we have done searches of the land registry and realized that there was a transaction that was not complete. And there's a claim that this individual owns this property. It's just that they never finished the transaction process. There are other claims that a particular individual, or this individual, bought this property, but he did not want it to be in his name because of some issue that you mentioned. But you name it in there. You put it within the court document. So it is a gruesome process that involves really going out and painstakingly looking for each and every property that you think, again, remember the word, you think an individual owns. This particular individual, we think he owns X property. We think even this property is registered in a certain company name. You dig deeper, go to the company's registry, ask who the owners are. And ask who the registry will not give you the list of beneficial owners. Go to court, compel them to give you a list of all those things. There may be other situations where, and one that I was handling as recent as this morning, where a creditor will come and say, but you've sold to me this, but this person who died sold to me this property. So they would then apply under different forms and say, either I'm a creditor and I demand to get a stake in this property. So what I would say, again, back to stress levels, why would you want your family to undergo such stress, such strain? Someone should know about it. Again, not a legal issue, but a social issue. Within your circle of friends, I encourage people to make them aware. Make them aware of your properties, make them aware of your will, because the process that we're currently undergoing that I've described is very expensive. Your family will be forced to incur money trying to go through this due diligence process across the country. If you're lucky enough to have property across the country and are fairly wealthy, You will be hiring private investigators to understand who owns what property. You will be going to land registries. You will be going to unclaimed financial assets, or the unclaimed financial assets organization. You will be going to stock brokerage firms to understand this. You'll be going to other families to confirm whether there's a child who was born and the parentage is linked to the deceased person. It's a very stressful situation. There are ways legally to address this, especially one person who's a creditor. He can go to court and say, I need to be part of this case, using various forms that can be used under the probate and administration rules. There are other ways in which you can tackle this, just having a sit-down family conversation. The other example that I gave to you earlier on, someone objected, or someone went to court and said, this family is not taking up letters of representation of administration, and is compelling them to go to court and start a succession case. People can go and do that. The reality, and perhaps that's why succession is so tedious, is that you will really have to go through those processes, and it's expensive. Why the stress is a $1 million question I keep asking.
Yeah, why the stress? Why the stress? Yeah, thank you for handling that issue. And maybe now I will go to a completely different question, which is the nature of assets. Many people will be tempted to believe that it is easier to maybe write a will on assets that are within the locality of the Kenyan geographical location. But assets these days could be offshore. They could be in stocks and shares of offshore companies. They could be in cryptocurrencies. They could be in speculative assets. All manner of assets that you may think about is what we are currently facing and thinking about, and even properties out of the country, real estate out of the country. So does this change the nature of administration, and can somebody be able to easily be able to access those assets? Should they be in the nature that, for example, you need to sell off or do all these things? And have you gotten to a point where somebody says they do not want to inherit a specific item or asset? So somebody receives maybe a piece of land, but they say, I don't want this piece of land. How do you go about now this process of handling all these very many dynamics as regards to wills and succession now, and even the issue of somebody doesn't want an asset or to inherit something?
Yeah, and again, that's a pretty important point. And I can tell you, sometimes when you go to institutions of higher learning, what you're taught, book theory versus what the actual theory is very, very different. And based on what you've asked, and I'll sort of tackle the first part of your question before anything else. I had a client come to me about 1.5 years ago.
Yeah.
The client was not Kenyan, was from an African country, out of African country that is not Kenya. His wife was also from an African country that is not Kenya. Yeah. So they are from two different nationalities, but they live in Kenya, and their children are born in America, and they have properties in Kenya, in their individual African countries, in America, and in the UK. That is very interesting, and that's a very global perspective, because they have had the advantage to work out of the country, meet in the US, come back to Africa, and settle in Kenya. However, their intention is to follow Kenyan law in dealing with their succession issues. Yeah. So one of the issues that we had to tackle was all these investments. And you talked about different forms of investment. Let's talk about bank accounts. Let's talk about property. Let's talk about money market funds. Let's talk about pensions with any international organization that you have. One of the critical things when we are drafting templates and we want to advise clients is if you have invested in a mutual fund, or if you've invested in a money market fund, or you have a pension, or you have some insurance scheme, I ask the clients to take a moment, go back to their original documents. Let's say, for purposes of this discussion, there's an education fund, or there's a death insurance scheme that you got into, a life insurance policy that you got into, and you listed your beneficiary as X, Y, and Z. I ask my clients to go back to let's say for Britain, for this scenario, I go back to Britain, ask them, when I die, based on the documents that I've signed today, what happens to my money? If you have invested in a money market fund out in the Cayman Islands, this client had literally got funds in the Cayman Islands. And the question I asked them, please go back and look at the documents that you initially signed. When you pass on, what have they said will happen to your assets? And the world is becoming a very global village, and we're hoping that Kenya will also is part of this global village and will become bigger and better, and people will become wealthier in one way or another. And as they do so, they keep investing. People are now looking to invest in Mauritius. You go to Mauritius, you invest in something on that side, and you ask, and then again, I tell the client, go back and confirm what you signed. Because sometimes some of these policies, life policies, education policies, anything that links to your death, it may be that someone is listed as a beneficiary, so you do not want a conflict between what you're stating in the will and what is stated in that insurance policy. And one of the issues we had to tackle 1.5 years ago was particularly if your money market fund that matures at this time and renews automatically, if you're to pass on, who have you written as a beneficiary there? And does that jurisdiction, whether it's a Cayman Island or Jersey or some other place around the world, a tax haven or a tax favorable country, does it recognize, what do you need to access that money? You may need a death certificate, but that death certificate, does it need to be notarized by a notary public in Kenya and then take it to Mauritius or the Cayman Island? Or is it that within the document that you signed, it says, please show us any death certificate, or please come with a court order to confirm so that we can release these funds? Very critical questions with regard to how to address that. And that example for me is very real. Two individuals from two different African countries, married not under Kenyan law, living in Kenya, children are American, investment in their own respective African countries, and investments all around the world. So you have to be, if you're living in Kenya, you say, my will will adhere to Kenyan law, and then a lawyer looks at it holistically within the context of Kenyan law. Not that you can access your property on that other side, you just have to be aware of the laws that are in that other jurisdiction. So that's the technicality that's involved in that, and people have to be careful. And even this client was keen to set up a trust in Kenya, and I said, do you really want to set up a trust in Kenya based on what you are thinking about? Because in some countries, when you invest there are inheritance law, inheritance taxes. If your property is passed on from one person to another, there's a tax that's applied. Luckily in Kenya, we don't have those taxes yet. But if you look at the way capital gains taxes have been reintroduced and are being introduced, maybe one day we'll have inheritance tax. So that's something that people need to be very careful of. That was me sort of addressing the first part of the question. There was a second part of the question you need to
So there was the second part of the question, which was to do with how you can be able to do basically the administration of such a will where assets are distributed. But in particular, it was also talking about what if somebody doesn't want to inherit these properties.
Right, that's the second part. Now, they are, and I have drafted templates that we use, and there's wording that we use that says if someone who has been given property, the legal term there is bequeathed. So again, people may interact with this word quite a bit. If someone has been given certain property and they don't want it, it reverts to what we call the residue. Someone in the report, the residue of the estate, it can revert to another person. So in drafting a document, and again, I'll go back to the discussion around, do you need a lawyer to draft this? I was very careful when I said it can be as simple as doing it yourself. However, it can also be as complicated as a lawyer providing wording to you that says, if someone doesn't want the property that you have given to them, they can pass it on to someone else. So there are different variations that we use within agreements to accommodate everybody. And some scenarios, again, when we draft wills, we have situations where many people have interacted with this one. You have an executor or executrix. That's someone who's in charge of managing your property and distributing the assets. Sometimes I ask clients, what if the person you've chosen dies? What next? So I ask them to give 1, 2, 3 options. Give option 1, if this one dies, option 2, this one dies, option 3. Some people will decide they want 2 people to be executors or executrix for a particular property, but then ask them, who is your backup in case one dies? Or if one dies, can the other person run the estate alone, or do they need a second person? Those are the intricacies if you have a big family. So there are ways in which we can incorporate wording to accommodate these different scenarios, particularly for your example, where someone says, I'm not interested in that property.
Thank you. Thank you for addressing that issue. So we come to the case of Nderito Gachagua. Rumors have it that the reason there was a lot of ease in distributing or executing that succession was because there was a clause that said that if any person objects to this will, then they also lose the right to claim any assets that they have been issued with. So basically, it's like a threat. If you challenge, you also stand the chance of not getting anything. So is that common practice, or was it something that was really beyond the scope of things that happens within Kenya, or is it a common thing that happens?
Okay, and I don't have the specifics of the Nderito Gachagua case, but as you mentioned that, something came to mind. Within succession property trust, there's something called the dead man's rule. And it has been fairly contentious over the years. Essentially what the dead man's hand rule, if I read it correctly, essentially what it says is it fair for someone who is dead to come back and start controlling how his property needs to be handled? Is that really fair? And in looking at some of these scenarios, the courts will analyze some of these legal principles and say, that's not equitable, that's not right. And the clause you mentioned, perhaps someone can come in and argue and say, that doesn't seem fair. Why is anybody who's objecting being limited to the property that they have, yet the nature of their dependency requires that they get more? So every scenario is unique, and every matter in court has to be addressed based on the merits of the case. It may be that the wife of Nderitu Gashaga may have been satisfied with what she had, doesn't want to ex property, or his brothers or his siblings or his sisters or other dependents may be content with what they have or may not be content. The question will then be, if there was indeed a clause such as that, is it fair? Is it equitable? Why is the dead man still coming to control his assets? If I'm not wrong, I'll probably check it out later on. It's a dead man hand rule or something of the sort. But yes, there's a principle in law that deals with that.
Thank you. And I guess we can also go to the next high-profile case, which is the inheritance case of this politician from Kiambu region, who, after death, children came out of the woodwork claiming heritage to him, saying he was our father. And this happens across high-profile individuals' death and succession. How do you go about handling such a case?
Yeah, again, it really depends on what they're claiming to a large extent. When you look at the Law of Succession Act, there's an order of priorities. If someone has died without a will, there is an order or priority in which property is distributed. And it incorporates spouses, former spouses, children who can be beneficiaries, whether young children or whether adult children. So anybody by law is required or has the ability to object to the distribution of a property. They just have to bring forth a very compelling case that says that I will get value from some of this property being distributed to me. I'm a dependent, I'm a legitimate child, and I should not be denied a right. That is really a matter of every case needs to be decided on the merit of it. But as a lawyer, we look at those and say, "Oh my, not again." But it's not our fight, in the sense that we were not involved when all these children were being born. It really depends upon the lawyers to argue the case based on what the client has proposed.
Thank you, Hunter. I think we can be able to summarize it there for now, but I think we should continue this conversation, because I'm sure other topics will come up, maybe questions will come up in this conversation. But for more detail and engagement, we will leave your contact in the description box. We'll also leave some of the contacts that you will provide to us so that somebody can be able to engage with you further and get to the point of writing a will, securing the assets, and ensuring there's continuity in so that we do not generate wealth